Your spouse has told you, I want a divorce. And the first thing you think is, well, I better get to that money in the joint bank account before my spouse does. But I'm here to tell you, that may not be the best idea. I've seen this happen more times than I can count. And while you may feel like you're protecting yourself, it can create legal and practical problems you never saw coming. Because here's what could happen next once the other spouse discovers the money's gone. Bills start bouncing. The mortgage payment is due. There isn't enough money for groceries or rent. And now everybody's angry. Emergency motions are getting filed, attorney's fees are increasing, and a divorce that may have moved forward smoothly now suddenly becomes much, much more contentious. In this video, I'm going to explain what can happen when one spouse empties a joint bank account during a Washington divorce, when it may create legal issues, and what you should think about before making a decision. My name's Charlie Shane, and I'm a Washington State family law attorney. Over the years, I've helped people navigate complicated property and financial issues during a divorce. And this is the one mistake I encourage clients to think about carefully before acting. When a divorce becomes reality, fear can take over. People worry they won't have enough money. They worry the other spouse will also drain the account first, and they worry about not being able to pay their bills. These decisions are all understandable, but I'm here to tell you that making decisions based on fear can make everything worse. Most people think the solution is simple. I'll just move the money now and figure it out later. Or they withdraw cash without keeping records. Or they transfer money into another account without documenting why. While people may think they're protecting themselves, they could at the same time make things infinitely more complicated. But here's why. Washington is a community property state, and courts may view moving money around in different ways. The court may want to know, why was the money withdrawn? How was it used? Was it spent on normal living expenses? Was it preserved? Did the withdrawal unfairly affect the other spouse's ability to pay bills or support the family? And unfortunately, I've seen people spend thousands of dollars arguing over a withdrawal that should have been handled differently. Before you move the funds out of the account, take a step back and ask yourself, am I protecting myself, or am I creating another issue that will have to be explained later? And sometimes there are legitimate reasons to withdraw the funds, but there are many times better ways to approach the situation. It's important to understand the potential consequences before you drain the account. The bottom line is, before you do something as drastic as draining a joint bank account, I would advise that you talk with a lawyer who can look at the facts and circumstances of your case and advise you as to whether that's a good or a bad idea. If you're considering divorce and you have questions about bank accounts, finances, or protecting your financial interests, schedule a consultation with my office. We'll discuss the facts unique to your situation, formulate a plan, and help you make wise financial decisions before you even get started on your case.